Be ready for the dictation. The dictation speed is 120 words per minute. 5 seconds to go. In a setback for the petitioners in the 2023 IT Rules Amendment case, the third judge opined that prima facie no case was made out to direct the union government to continue its statement and not notify the fact check unit. Justice ruled that the balance of convenience favors the union, considering the government's submission about not using the FCU to censor political opinions, satire, and comedy. Additionally, any action taken after notifying the FCU would be subject to the final outcome of the petition and wouldn't cause irreversible damage. In my opinion, no case has been made out to direct that the statement made on behalf of the non-application applicants that the fact check unit should not be notified should be continued during present proceedings as an order of the court. The court, however, referred the matter back to the division bench of two justices for pronouncement of orders on the interim applications filed by petitioners and others. They sought to restrain the government from notifying the FC till final opinion on the challenge to the 2023 amendment to the IT Rules 2021. According to the rules, the government should establish an FCU to identify fake, false, and misleading information about its business on social media. Chief Justice assigned the matter to justice after the division bench of justices delivered a split verdict on January 31, 2024, while Justice Patel held that the rule should be struck down in its entirety. Justice Gokhale held that it was intra-vires. The judgments were divergent in all aspects, including the question of interim relief. Therefore, the petitioners filed the present interim applications. The petitioners argued that both justices agreed that the amended rule in its concurrent form violates the freedom of speech. Solicitor General argued that there cannot be an interim order which encourages public mischief at the behest of a few individuals. Advocate Gautam Bhatia for the Association of Indian Magazines outlined the criteria for interim relief: prima facie case, irreparable damage, and balance of convenience. He argued that the division bench agreed that the amended rule violates and has a chilling effect on free speech. Therefore, a prima facie case is made out. Since a safe harbor is fundamental to how speech operates online, he argued that the deprivation of a safe harbor would cause irreparable injury. Once the prima facie case is made out, the government has to burden to show that the balance of convenience lies against the grant of interim relief. The learned senior advocate for the petitioner emphasized the center's previous commitment not to notify the FCU until a judgment was reached in the challenge to the IT rules. He noted that this statement had been reiterated on 11 occasions. He contended that the split verdict by the division bench only represented an opinion and not a judgment, implying that the Union of India was obligated to maintain its stance until a final decision was made. He pointed out the stark divergence between the opinions of the two judges on the constitutionality of the amendment to the IT rules. He argued that failing to grant interim relief would render the petition ineffective and deny the petitioner fair recourse.